All right, I'm keep on talking. Wait, um, connection weak. What do you mean connection weak? I'm in a strong area. How the connection is weak in this? What? How am I losing connection to this? Wait, that doesn't even make sense. Yeah.
Testing 1, 2, 3, 4. Check, check, check. 1, 2, 3, 4. Checking 1, 2, 3. You see audio? You don't see it? Oh, okay. We getting it in the back. 1, 2, 3, 4. Check, 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 check. Where you plugged in? Are you plugged in? You're not plugged in.
Good evening, and welcome to the second special public hearing on the board's proposed rules on restrictive housing. We scheduled this hearing to begin at 5:30 p.m. to accommodate a public request that we hold a hearing after work hours. We are grateful for the public comment we have received so far, including the 30 people who spoke at our first public hearing earlier this month. We continue to learn from all of you, and the restrictive housing rules will be improved by your input. The proposed rules, which were publicly posted on October 29th, are designed to ensure that people in the department's custody are placed in restrictive housing in accordance with due process and procedural justice principles, and are confined in the least restrictive setting and for the least amount of time necessary to address the specific reasons for their placement and to ensure their own safety as well as the safety of staff and other people in custody. To encourage input from people in custody, correction officers, and other facility staff, the board worked with the department to post flyers in the jails announcing the proposed rules and explaining how to obtain a copy and submit comments. The department posted flyers in each jail's staff locker room, law library, visit area, and clinic. The department is keeping a copy of the proposed rule and related materials, which includes the statement of basis and purpose, in each facility's law library and office of the Deputy Warden of Administration. The board thanks the department for its assistance in this important outreach effort. Additionally, if people in custody, correction officers, or other jail staff call the board and request a copy of the proposed rule package, we will mail them a copy. We also have created a voicemail box so that anyone, including people in custody and people who work in the jails, can call and leave comments via voicemail. The board recognizes the importance of capturing the voices of people in custody and uniformed staff about what it's like to reside in restrictive housing and what it's like to work there. Thus, at the request of the board's ad hoc rulemaking committee, board staff interviewed correction officers and people in custody in various restrictive housing units as part of the fact-finding and rules development process. The board is grateful to the correction officers and people in custody who shared their experiences with board staff, as well as board staff's dedicated work in this regard. The board also encourages jail staff and people in custody to make their views known during the CAPA process. The board will review all comments, including comments submitted anonymously via phone or in writing. Finally, we recognize that not all people who want to provide input on the rules wish to present public testimony or submit written testimony. If you or someone you know would like to comment, but the methods we've set up don't work for you, please reach out to board staff and we will work with you to find a way to best receive your comment. You can contact the board by calling 212-669-7900 or emailing at boc@boc.nyc.gov. We are also exploring additional ways to expand avenues for comment, such as soliciting feedback from correction officers and people in custody on site at Rikers Island. Today, we will hear testimony from the public, and we will continue to welcome written testimony via mail, email, fax, or posting to the city's rulemaking webpage through January 3rd, 2020. The board will carefully consider all comments made at the hearings and submitted in writing or voicemail and determine whether revisions should be made to the proposed rules. The board will submit final rules for certification by the law department in time for a final board vote at a future public meeting. Under CAPA, any rules adopted by the board will take effect 30 days after the board vote. Before we begin our public comment tonight, I must make two difficult announcements. The first is that the board is deeply concerned about the attempted suicide of Nicholas Feliciano, a young man who was in DOC custody. We send our thoughts to Nicholas and his family at this difficult time. The system also must urgently learn from this tragedy. Self-harm and suicide are public health issues in jails and prisons across the country. The board's new minimum standards regarding serious injury reporting requires new monthly public reports on self-harm. We will begin publishing these on our website soon. The board has begun its investigation into this suicide attempt using a Sentinel events model that impartially reviews the incident to identify policy and practice improvements needed to prevent future acts of self-harm or suicide. While our investigation has just begun, it is clear that we will need to review how the department and CHS respond to acts of self-harm and suicide. Each act of self-harm must be treated seriously and has the potential to cause death or lifelong injury. The second announcement concerns a recent death in custody. It is our practice to announce each death, including the date, facility, and age of the deceased. On November 23rd, 2019, a 55-year-old man in the department's custody died at Elmhurst Hospital after being transported there from AMKC. The board is reviewing this death as we do all deaths in custody. We will now turn to today's agenda to hear public comment on the restrictive housing proposed rule. I will call 3 speakers at a time. While the first speaker is providing testimony, the other 2 people can sit in the front row. Speakers will be limited to 4 minutes, and the iPad on the stage will tell you how much time you have left. First, I'm going to call Councilmember Daniel Drum. Councilmember. Good evening.
Good evening. First, I want to express my gratitude to the board members and staff for your work on this issue. The proposed rules show a concerted effort to incorporate the concerns that many individuals and entities, including myself, have expressed over the years. I would, however, encourage the board to go a much-needed step further by adopting the following basic premises. First, recognize that solitary confinement, or whatever name the DOC decides to brand it, is a complete and utter failure and must end. Second, seize the opportunity to replace the existing system and its attendant culture of brutality and violence, just as the physical facilities are being replaced with smaller ones focused on reentry. Almost all individuals in custody will, at some point, return to their communities, our communities, and it is incumbent upon us to instill the tools these individuals need to manage stress and conflict as positively as possible. Specifically, I ask that the rules be amended to end restrictive housing for non-criminal infractions and instead implement restorative measures wherever possible. In no case should any placement exceed 15 days based on the UN standard. And reserve restrictive housing for temporary separation needed to secure facilities when facing imminent documentable threats. Facilities should rely on therapeutic alternatives that minimize punitive aspects for those with a wide range of mental health issues. There is precedent for this approach, namely the CAPS units. I also want to talk about the need for procedural reforms, which are critical given the widely documented abuses of power in DOC facilities. The rules should, among other things, ensure lawyers are present for all proceedings and that truly independent adjudicators make the critical decisions, and ensure that rights are read to individuals where there is any possibility of a future criminal prosecution based on the incident in question. Finally, there should never be placement in restrictive housing unless there is a clear path to release into a less restrictive unit. I applaud the board's stated goal in accordance with the Mandela rules of placing restrictions on people in custody that are limited to those required to achieve the appropriate objectives for which the restrictions are imposed. However, the DOC has long struggled to respect the basic human rights of individuals in its custody. As this process has been underway, the New York Times reported, as you have mentioned yourself, Madam Chairperson, that COs stood idly by while teenager Nicholas Feliciano tried to hang himself. An intensive level of oversight is absolutely necessary given the tragic history of our jails. I have worked closely with and befriended several survivors of this government-sanctioned torture. I pray that this board will hear their cries and also remember those who have not survived and end the practice of solitary confinement once and for all. Thank you.
Thank you, Council Member. Council Member Keith Powers. Good evening, Council Member.
Good evening. Thank you, and good evening to everybody, and thank you everybody who's here tonight. I'm City Council Member Keith Powers, Chair of the New York City Council's Committee on Criminal Justice. Before I start my testimony, I just want to thank the board for holding an evening meeting and holding multiple hearings, because I do think there are many individuals who want to be here and are impacted either because of their workday or not being able to make it on a specific day. So I want to thank you for holding multiple hearings and at both morning and at night. In June, I joined Speaker Corey Johnson in a letter to the board requesting for you to take up rulemaking on this issue. So I'm encouraged that the Board of Correction is here today and has started this process to update restrictive housing rules in our city jails. New York City has been a leader in a number of issues related to the criminal justice system, but most notably our reduction in solitary confinement and restrictive housing. And I do want to note, just off testimony, that I do think it's important to remind ourselves about our leadership in terms of this issue and where we are today relative to many other jurisdictions. And I appreciate the board's effort to create a clear set of guidelines to limit the use of solitary confinement or restrictive housing, however you want to call it, a practice which has been condemned by international bodies like the United Nations for its psychological effects and failure to address underlying causes of violence or to prevent recidivism. I've submitted longer testimony, which you have, that highlights many of the concerns that folks have about restrictive housing, and you're going to hear from many of my colleagues, just as you have, including the Speaker of the City Council, with the dangers of restrictive housing, particularly solitary confinement. I'm going to focus my testimony on specific parts of the proposal that I hope the board will consider as it moves forward with rulemaking and the proposal you have before you today. First, the board should clarify qualifications for punitive segregation and strengthen the exclusions. Throughout the board rules, as I was reading them even today, it references grade 1 violent infractions as the standard for placement in punitive segregation without a clear definition of what constitutes a grade 1 violent infraction. In fact, the definition of a grade 1 violent infraction that I saw defines it as an infraction that places an individual into punitive segregation. Does not seem there is a clear definition or a clear outlining in the actual rulemaking of what are the infractions that would put you in there. Second, I would hope that the board will also clearly delineate what constitutes, additionally, people with, there are exclusions for people in punitive segregation level 2, that includes people with serious medical conditions, intellectual disabilities, elderly individuals, and pregnant women. They obviously should not be placed in punitive segregation, and we hope that those will also be reflected in punitive segregation 1 as well. Second, Councilmember Drum mentioned it, but individuals sent to punitive segregation should also be allowed to have legal representation at the hearing. In the conversations I've had with folks, stakeholders, I understand that there are some immediate challenges to doing that, but the minimum, the DOC and the BOC should explore a pilot program immediately to be able to provide representation in our city jails. Third to that is there should also be an appeals process for placement in punitive segregation and timely reviews that include program and clinical staff as well. Fourth, there's policies here around lock-in with a maximum time for lock-ins before approval is required by the board. I think there are many of us who aspire to ensure that lock-ins are not used as an alternative method for isolating individuals, and would like to see some of the policies strengthened about lock-ins in both time and process for lock-ins. Fifth, the board should explicitly require congregate programming and individualized needs assessments in restrictive housing units that address root causes of violent behavior that will be crucial to creating real rehabilitation, and that program should include therapeutic and restorative justice programs. Finally, there is an end to restraint desks. However, I think 2 years is a long time frame for implementation of that, and would ask that the board end those restraint desks on a faster timeline, or at least provide us a clear justification for why that's not possible. I just want to say, since we've done this letter asking for the board to take it up, I've met with many individuals who've been both placed in solitary confinement, as well as those from the department, the board, the correctional officers, and advocates for criminal justice reform. And I do believe that we have to approach this issue carefully and comprehensively. You're going to hear from many people today about the dangers and the harms that can be caused by long-term, especially long-term solitary confinement. I've tried to make some recommendations that are implementable today, but I do want to recognize practical considerations in our implementation of those. And I do, as we've had this conversation, and you'll hear today as well, do actually, do agree that the safety of all individuals who work in our city jails is very important. It's important that we have an environment and rules and rulemaking and laws that keep both the staff and incarcerated individuals safe. And I do ask the board to consider that as well. But the opportunity here to institute sweeping reforms to restrictive housing practices at DOC does not come often. And we know through this process that it is difficult to come to. So it's crucial that we get it right. And as the city and the state are moving towards landmark reforms to our correctional system, we should ensure these reforms uphold this city's commitment to a fair and more humane justice system. And I believe this rulemaking is a crucial step towards that goal. Thank you.
Thank you, Council Member. Council Member Carlina Rivera. Good evening, Council Member.
Hi, good evening, everyone. Thank you. Thank you for hosting this after work, being very inclusive and trying to create a process that I know has included heated argument and debate and a lot of passion. And I just want to thank everyone for their time. Thank you for the opportunity to submit testimony this evening. I am here once again to call on the board to abolish solitary confinement in all forms in city jails. The Board of Correction must seek alternatives that respect the safety and humanity of all incarcerated people instead of the piecemeal reforms before us today that will not protect the lives of every New Yorker. 15 days of solitary confinement is 15 days too many, and the board needs to remove exceptions to the standards for solitary. We all know the unnecessary tragedy that someone whose names I don't typically invoke because I try to respect that human experience and their families, but this one particular example of Layleen Polanco and her experience during the last 9 days of her life in solitary confinement, I am unable to shake, and where she ultimately died from complications that could have been prevented. Should that appalling and tragic example not be sufficient for our case, you might consider studies that have shown solitary to be unjust and inhumane. The New York Times analyzed nearly 60,000 disciplinary cases in New York and found that Black inmates were 65% more likely to be sent to solitary confinement compared to white inmates. Solitary cannot continue in any form, given the widespread evidence that it causes severe and long-lasting psychological, emotional, and physical harm. We heard of its devastating impact loud and clear at the last hearing from formerly incarcerated people, family members of currently incarcerated people, legal experts, faith leaders, and community members. I would also like to note the absence of the Department of Correction at the previous hearing on December 2nd, and that failure to engage, because that is why we are here, engagement and not isolation. That absence leaves me with serious concerns about intentions to carefully consider the proposed changes and the lived experiences of survivors of solitary. As a city that aspires to uphold progressive and inclusive ideals, New York City must honor the rights of all people who are incarcerated. Policy alternatives to the BOC's proposal already exist. I strongly urge the Board of Correction to adopt the Halt Solitary campaign's blueprint to end the practice. The evidence against its continued use is simply too compelling and the stakes are too high. Therefore, we must pursue the alternatives before this system experiences another tragedy. Thank you very, very much for allowing me to speak today.
Thank you. Brenda Cook from the Department of Correction, the Chief of Staff. Good evening.
Good evening, and thank you for letting me have the opportunity to speak. I'm encouraged by the board's commitment to meaningful corrections reform in the city of New York. We at the Department of Correction are very encouraged by the productive dialogue between our agencies in the formulation of the proposed restrictive housing rules published by the board that we're here talking about today. As you're aware, the New York City Department of Correction, in collaboration with the board, has implemented some of the most progressive restrictive housing reforms in the nation over the past 6 years, many of which have been highlighted here today. As an agency, the department is not new to significant and systematic reform and the hard work such progress requires. In 2013, we eliminated the use of punitive segregation for all seriously mentally ill individuals in custody. In 2014, we eliminated the use of punitive segregation for adolescents aged 16 to 17. In 2015, the use of punitive segregation for adults in the department's custody was fundamentally transformed by the creation of a tiered system of proportional responses and long-term management alternatives. Previously, punitive segregation had been the only proposed response to all infractions. In 2015, punitive segregation 2 was created in response to nonviolent or grade 2 infractions. Punitive segregation 2 individuals receive 7 hours out of cell each day. With the addition of this unit, punitive segregation now narrowly applies to only violent grade 1 infractions. In June 2016, the department led the nation in the elimination of punitive segregation for all 18-year-olds. The department further led the elimination of punitive segregation nationwide for the remaining young adult population, 19 to 21-year-olds, in October of 2016. We thank the board for the support that the department received in implementing these tremendous reforms. The department has further implemented some of the most progressive punitive segregation sentencing reforms in the nation. For example, all violent infractions, with the exception of assaults on staff that cause serious injury, currently result in a maximum penalty of 30 days. Most violent infractions, however, result in penalties of fewer than 30 days and take the individual's infraction history into account during sentencing. Further, infractions from previous incarcerations are no longer applied to an individual's current incarceration. This practice differs vastly from the practices of many correction departments across the country, where indefinite punitive segregation sentence lengths are imposed in response to non-serious or non-violent behavior. In June 2019, the department implemented an out-of-cell structure in punitive segregation that affords all individuals a minimum of 4 hours out of cell each day, including 3 hours for engagement in outdoor recreation and congregate activities, where additional hours may be provided for mandated services. As of June 2019, the department no longer operates punitive segregation units with 22 hours of lock-in. This differentiates the department's punitive segregation units from those defined as solitary confinement under the United Nations Mandela Rules. We're incredibly proud of these achievements and the department's place as a national champion of restricted housing reform, and must recognize the work and dedication from staff that has proven so integral to implementing these changes. We're incredibly thankful to our partners at the Correctional Health Service, whose creativity and passion for this important work has led to the creation and co-management of clinical alternatives to punitive segregation, otherwise known as CAPS units. CAPS units provide standard general population lockout time, 24/7 on-unit clinical support for individuals with serious mental illness who commit violent infractions and previously would have qualified for punitive segregation placement prior to the aforementioned reforms. The department staff have also worked incredibly hard to create alternatives to punitive segregation for young adults, such as enhanced supervision housing and the secure unit. These units provide for the safe management of young adults with the most violent behavior in custody, while ensuring access to rehabilitative programming designed to address root causes of violent behavior and criminogenic risk factors. The department, in collaboration with the board, has made significant improvements to these units in order to ensure consistent access to meaningful services and a clear pathway for level or phased progression and re-entry into general population. The department frequently receives visits from correctional leaders representing agencies from across the country who are interested in replicating these reforms and punitive segregation alternatives in their own jurisdictions. All of these achievements and the dedication from staff that make them a reality have resulted in fundamental changes to the operation of punitive segregation units and a landmark reduction in the use of punitive segregation. The department has approximately 80% fewer people in punitive segregation today than we had 5 years ago. We are not the same department that we were just a few years ago. With these achievements, they represent significant progress, but we recognize the need to go further. We are eager to continue building upon these reforms, and we support many of the proposed rules made by the board, including the elimination of the automatic $25 fine imposed on guilty infractions, the further limitation of punitive segregation sentence lengths, while maintaining a maximum of 60 days for individuals who cause serious harm to DOC, CHS, or program provider staff and volunteers. The increase in the frequency of reviews for individual and the most restrictive levels of ESH, thereby potentially reducing the time a person spends in a program desk. Further changes to the use of program desks during lockout in facility housing units, and the provision of additional levels of review and support for the due process around restrictive housing placements. While we support these reforms in the rulemaking process, we acknowledge there are still areas of proposed rulemaking where additional discussions is needed in order to ensure the department is able to safely and effectively operationalize the final rules. These include, for example, the potential for individuals who commit multiple serious infractions within the same few months to go without meaningful disciplinary action for each act due to the proposed limits to the punitive segregation backlog and the 6-month sentence limit. Reduced incentives for level progression in ESH, the regulation of de-escalation protocols, which are a security operation and not a form of restrictive housing, restrictions on strategies for managing individuals who have persistently engaged in serious violence, and the requirement to videotape various due process refusals, which will duplicate current mechanisms for accurate recording while requiring substantial spending that may otherwise be utilized for expanded programming and services. While these latter impacts require further discussion in the coming weeks, we acknowledge that the rulemaking process is important and fair. We are confident this process will produce a set of proposed rules that will ensure that individuals who commit serious violence while in the department's care receive an appropriate consequence that imposes the least restrictive possible and maintains safety for everyone. We are committed to upholding values of rehabilitative and procedural justice, and we believe these rules are aligned with that commitment. The safety of all people who stay and work in our facilities remains our ultimate concern, and we look forward to continuing our discussions with you, the board, and as we work to finalize rules that are safe and further affirm the department's place as a national and global leader on restrictive housing reform. Thank you very much.
Thank you. I'll now call Ben Farber from Correctional Health Service. Good evening.
Good evening, Ben Farber, Correctional Health. We applaud the Board of Corrections' intent to set parameters in an effort to ensure that punitive segregation is used judiciously and to establish explicit restrictions in order to help mitigate the detrimental effects of confinement. CHS is grateful to the Board for its partnership in this endeavor and for reflecting CHS's input in the proposal. The proposed rules include provisions to expand the mental health and medical exclusions for punitive segregation. Exclusions for punitive seg 1 would expand to include pregnant individuals, individuals within 8 weeks of pregnancy outcome, individuals caring for a child in the Department of Corrections nursery program, and individuals age 55 and older. The mental health exclusion for individuals diagnosed with serious mental illness would broaden to include those diagnosed with an intellectual disability, conforming with CHS current practice. The proposal underscores a separate exclusion for individuals with serious medical conditions from punitive segregation 1 and 2. Although this exclusion already exists in the BOC minimum standards, the term serious medical conditions has never been clinically defined. As a result, the exclusion has proven to be challenging to implement and monitor. To address this and help ensure implementation of this medical exclusion moving forward, the Board has requested CHS to identify certain medical conditions and corresponding markers of acuity and advancement of disease for which separation could present a higher level of risk. For CHS to clinically define, subject to the Board approval, exclusionary medical conditions for punitive segregation is groundbreaking. Although the board's intentions are to exclude individuals at elevated risk in punitive segregation, there is no body of medical literature that reliably guides the assignment of health risk to any individual. There are conditions that are risk factors for outcomes that are worse than baseline harm, but the absolute risk of harm of punitive segregation to an individual is unknowable and cannot be predicted. Moreover, the possibility of risk of worse than baseline harm is present for all persons, regardless of clinical condition. The board's request of CHS to define serious medical conditions for this purpose is innovative, and CHS can only attempt to identify health risk. Because the board is the sole entity that can weigh the health risk against any security benefit, CHS appreciates that the board will approve this list of conditions and markers and all future modifications to it. We are grateful to the board for providing correctional health this opportunity to share additional input on the board's proposed restrictive housing rules, and thank you for your time and consideration.
Thank you very much. I'll now call Alana Sivan from Council Speaker Corey Johnson's office. And Asher Freeman and Rama Isa Ibrahim, you can make your way to the front as well. Good evening.
Good evening, members of the board. My name is Alana Sivan. I'm a senior counsel within Speaker Corey Johnson's legislative division. I'll be delivering comments on his behalf today, and we will submit written comments as well in the next few days. As Speaker of the City Council, I have been actively engaged in all of the issues surrounding our city jails. I have visited Rikers Island multiple times, including the punitive segregation unit just 2 months ago. I have repeatedly said that we need to do more than close Rikers if we are going to truly change the culture of the Department of Correction. I have also said repeatedly and publicly that solitary confinement is cruel and unusual. It is torture. It is degrading. It is sick and unacceptable. I said it on March 24th, 2015. I said it on May 9th, 2016, May 26th, 2016, and just 2 months ago on October 17th, 2019. And I am here to say today unequivocally that we must ban solitary confinement altogether. And when I say that we should ban solitary confinement, I don't mean that we should introduce new solitary units and call them something else, like separation status. I don't mean that we should continue to shackle teenagers or anyone else to their desks while they are out of their cells for the next 2 years, or that we should allow for the existence of units where rec time means being let out into a small cage. I mean that we should get rid of punitive segregation 2, restricted housing units, and anything else that looks and feels like solitary confinement. Because we know that the impacts of solitary confinement are devastating. Dr. Homer Venters concluded that people in solitary are 7 times more likely to engage in self-harm and 6 times more likely to engage in fatal self-harm. Psychiatrist Stuart Gracian concluded that solitary can cause hallucinations, panic attacks, and paranoia. Laylene Polanco, Jason Echeverria, Bradley Ballard, and Khalif Browder, may they rest in peace, might have been alive today if we hadn't put them in solitary. But solitary is not just deeply and morally wrong, it also doesn't work. There is no proof that solitary has any significant effect on reducing violence. A study by the National Institute of Justice in 2016 stated that there is little evidence that administrative segregation has had effects on overall levels of violence within individual institutions or across correctional systems. Studies of new supermax prisons, which only have solitary units in Minnesota, Illinois, and Arizona, showed no significant difference in violence after their opening. And here in New York City, though some claim that solitary is necessary to keep people safe, the data indicates that the department's drastic cuts in its use of solitary in 2015 did not impact the rates of violence or the use of force in our jails. Sadly, many of those rates rose steadily before 2015 and have continued to rise ever since. In Colorado, where they decreased the use of solitary by 85% in 2012, Studies show that assaults on staff, assaults between people in custody, and use of force all declined in the 4 years after their changes went into effect. And the impact of solitary goes beyond the walls of a jail. Studies from states like Florida and Washington show that recidivism rates are dramatically higher for those who are incarcerated in solitary confinement. We can do better. In San Francisco, where they provide people with some of the most violent histories with targeted group programming through the Resolve to Stop Violence program, recidivism for program recipients is down 46.3%. And the number of violent incidents per year within units with this program went down from 24 to 1. Meaningful alternatives to solitary confinement exist not only across the country, but right here in New York City. Just look at the success of the CAPS units. The people in those units, but for a diagnosis with an SMI, would be housed in some form of solitary confinement. But instead, we've chosen to give them treatment, group therapy, and constant programming, and what is the result? A 50% increase in medication adherence, a 25% decrease in both self-injury and injuries sustained as a result of fights, and a reduction in 30-day rehospitalization rates. And according to the last quarterly report, 0 incidents of Class A use of force or recovery of contraband. Compare that to the 37 instances of contraband found in ESH in the last quarter, or the 5 instances of Class A use of force. I visited a solitary confinement unit this year, and I was horrified. These cells are a stain on our city, and I refuse to believe that we cannot do better. Members of the board, I am asking you to listen, not just to me, but to the cries for help of the people who are living in solitary, and to the advocates and the survivors of solitary confinement who have come to board hearings time and time again to relive the trauma of their experiences, hoping that we will move to the right side of history. We can get there. You can change the rules. Change the cap on solitary confinement from 15 days to 0. No exceptions. Mandate truly therapeutic and treatment-based units that give people at least 14 hours out of their cells with at least 7 hours of congregate programming. And do not allow one more day to go by where we continue to use enhanced restraints. I am proud of the work that this board has done to better the lives of people in jail custody. These rules are a good start, and I am in support of many of their provisions. The elimination of $25 fines is important to ensure that we are not further impoverishing people who are already too poor to pay bail. And requiring the DOC to provide the board with a written, comprehensive implementation plan is necessary to ensure that the department doesn't open new solitary units and disguise them with another name. These are good things. But I am asking you to go further. The people in our city's jails need you to go further, to end solitary confinement once and for all. Thank you.
Thank you. Thank you. Good evening.
Good evening, everyone. My name is Asher Freeman. I'm the Legislative Director for Councilmember Antonio Reynoso, and will be delivering remarks on his behalf. I want to thank the Board of Corrections for holding this important hearing today and beginning a discussion around the practice of solitary confinement. The BOC has an incredible opportunity to make history on criminal justice reform in New York City with this process. Since its inception, the criminal justice system in the United States has been based on vindictiveness and revenge, often crossing the line into cruel and unusual punishment. Furthermore, our system has unjustly targeted people of color throughout its history, making it difficult to assert that there's any justice at all present within the institution. Things are changing, though, and while democratic systems often move slowly, when we are talking about people's human rights, it is critical that we act with the necessary level of urgency. Each member of this board has the power to not only move our city forward, but to restore dignity and humanity within our criminal justice system. We're here today to talk about a proposed rule on the use of solitary confinement by the Department of Corrections. As someone who believes that solitary confinement is torture, I'm saddened that we are having a conversation like this. You can't make rules around torture. How can we take any human being and completely cut them off from human contact for any period of time? How can we do this to folks who are dealing with layers of trauma and often suffer from mental illness? We must take a stand on this issue. We must show that New York is a leader on human rights and that we have moved forward towards a justice system that reflects the values our city represents. Running a jail is not easy, and addressing violence within a facility is a complex and fraught task. However, if we are going to deprive people of their liberty, it is our collective responsibility to ensure that these individuals are treated with a level of dignity that reflects their status as a human being. This begins with enacting the blueprint to end solitary put forth by Halt Solitary and the Jails Action Coalition. I want to appeal to the members of this board to do what you know to be right. We must ban solitary confinement once and for all. No rules that we place around the use of torture negates the fact that we are engaging in torture. For once, let us take bold action. Let's not take a piecemeal approach to ending a practice that we know to be indefensible. I want to thank the members of the board for their time, and I again urge you to seize this historic opportunity and end the practice of solitary confinement in New York City once and for all. Thank you.
Thank you. Good evening.
Good evening. My name is Rama Isa Ibrahim, and I serve as the Deputy Public Advocate for Justice, Health, and Safety in the Office of Public Advocate Jumani Williams. As Public Advocate Jumani Williams testified at this board's hearing on December 2nd, our office unequivocally supports ending the torturous practice of solitary confinement and urges the board to revise its proposed rule on restrictive housing to reflect this moral imperative. I would like to use this opportunity to raise concerns that our office has around this rulemaking process. At the December 2nd hearing, many members of the public, including many who had personally experienced solitary confinement, raised numerous shortcomings present in the rule before us today. In response to these testimonies, board member Robert Cohen stated, "A lot of the things you're asking for should be in the rule. I hope they end up back in the rule. Some of it just disappeared." The natural question that follows is, how are critical human rights protections simply disappearing as this process progresses? It is the understanding of our office that the board had previously intended on the following provisions being included in the rule, but they were ultimately removed. In addition to supporting the complete end to solitary confinement, the Public Advocate's Office calls on these provisions to be included in the rule. 1, increase due process protections in disciplinary hearings, including the right to counsel or an advocate. 2, clearer mechanisms and time limits for getting out of restrictive housing. 3, the immediate end to the use of restraint desks. 4, a pilot program for introducing restorative justice principles into disciplinary cases, including staff trainings and usage of peacemaking practices. And 5, the codification of a 5-hour requirement for programming as a minimum standard. In this context, the repeated delays around the introduction of this rule and the mayor's unprecedented decision not to renew the term of Commissioner Breanne Hamill, who had worked extensively on restricting solitary confinement, appear to be a product of deliberate efforts by external parties to interfere with this board's vital work on this issue and water down the rule before us today. The Board of Correction is intended to function as an independent body that advances improvement and change towards safer, fairer, smaller, and more humane New York City jails. The Office of the Public Advocate implores the board to fulfill this function by passing rules that will end solitary confinement in New York City once and for all. The comprehensive blueprint put forward by the New York City Jails Action Coalition and the Halt Solitary campaign makes it clear that the board has the ability to make this happen through this rulemaking process. The reforms that are needed here are not radical. They would simply expand existing standards and programs like CAPS, the Clinical Alternative to Punitive Segregation, that have proven a track record of success in New York City jails. Further, in allowing for clearly regulated separation in cases of serious behavioral disruption, but prohibiting punitive isolation, these reforms prioritize the safety of those in DOC facilities without violating basic human rights, endangering health, and exacerbating behavioral issues. The Office of the Public Advocate urges the board to adopt the recommendations made in the blueprint and improve the rules before us today accordingly. Thank you.
Thank you very much. And before I call up the next three people to testify, I did want to note that board member Bobby Cohen very much wanted to be here this evening in person. He is unable to attend this meeting in person. He is, however, tuning in to hear the testimony from where he is. So he very much wanted me to let everyone know that he was unable to attend this evening. And now I will call Zachary Katz-Nelson from the Independent Commission on New York City Criminal Justice and Incarceration Reform, Elias Husamuddin from the Correction Officers Benevolent Association, and Mary Lynn Whirlwas from the Legal Aid Society Prisoners' Rights Project.
Good evening, everyone. I'm Zachary Katz-Nelson.
Good evening.
I'm the Policy Director at the Independent Commission on New York City Criminal Justice and Incarceration Reform, commonly known as the Littman Commission. As we continue down the path to shut the Rikers Island jails and move towards a much smaller system in our city, something our commission has espoused and fought for over the past 3 years, alongside so many people in this room, we must immediately begin to implement a new vision for how that system will operate. Restrictions on solitary are one place to start. I speak today based on my decade and a half working in jails and prisons around the world, either representing people directly or investigating conditions in the facilities. I have toured numerous solitary confinement units and sat down with easily over 1,000 people who've been held in solitary confinement, from death row to Guantanamo Bay to Rikers Island. Unquestionably, we need accountability within jails. Acts of violence must have consequences. But solitary breaks people. After just a couple days in solitary, people start to suffer from headaches, vertigo, heart palpitations, insomnia, memory loss, and inability to maintain a coherent flow of thoughts, and disorientation in time and space follow. Anxiety, paranoia, and even hallucinations and psychosis develop. In the end, many of the people I met with were no longer able to properly assist me with their defense, even if they'd been fully capable of doing so before they were subjected to solitary. It does not take long for the harms to begin. A study out of Norway found that almost half of people start to suffer from the harms of solitary after fewer than 40 hours. A review of 200 people in solitary by Dr. Gracian, whom Ms. Sivan referred to earlier, who's a psychiatrist at Harvard, found that just after a few days in solitary, EEGs demonstrated brain patterns consistent with stupor and delirium. For so many people, the pain and trauma of solitary is too much. You heard the stat earlier from the study by Homer Venters and others at Rikers. People in solitary 6 times more likely to commit self-harm. Solitary also puts correction officers at increased risk. Dr. Gracian found that almost half the people who spent time in solitary had uncontrollable thoughts of revenge, torture, and even mutilation of correction officers. And the same proportion had loss of impulse control, resulting in random violence. This harms everyone. And solitary has serious ramifications after people are released. A Florida study of recidivism found people who had been in solitary were 20% more likely to commit violent crimes, even after controlling for criminal history and regardless of how long the people spent in solitary or how long ago it had been. Researchers in North Carolina tracked over 200,000 people after their release from prison. They found that people who had been held in solitary had a 78% higher chance of suicide and a 127% higher chance of death by opioid overdose. These proposed rules are certainly an improvement on the current system. I'm glad to see New York catching up with places like North Dakota and Colorado, but we need to do more. We should envision a day when solitary would no longer be used in our jails and do everything we can to achieve it. The Cook County Jail, where over 5,000 people are incarcerated, eliminated solitary in 2016. Assaults there, including on staff, have declined significantly. At minimum, the proposed rules must be improved. For instance, DOC should be required to develop behavior and programming plans for people in punitive segregation also, and provide programming during the 4 hours people there get out of cells. When steady staff who are trained to work in disciplinary units are unavailable, replacement staff must also have such training. And there's no legitimate reason to provide 2 years for DOC to eliminate the blanket chaining of people to desks. The proposed rules are a positive start, but we can do even better. We look forward to working together to make that happen. Thank you so much.
Thank you. Good evening.
Good evening. How you guys doing? Did the clock just started working all of a sudden? I've been sitting here for about an hour. It wasn't working. It's working now. Good evening. There's so many things that, first of all, my name is Elias Husamuddin. I'm the president of the Correction Officers Benevolent Association. And there's so many things to be said and to address, but I'll try to stay focused on a few. One thing I will say is, can you imagine if the Speaker, Corey Johnson, and the rest of the council people who come up here to speak would put the type of energy and resources and keeping people out of jail as they're putting in concerning and talking about punitive seg? I mean, if they did their jobs and there was job programs and job training and educational programs, then we probably wouldn't be here. Here's the reality. Currently, we have approximately 6,400 inmates / detainees in custody, 6,400. Out of the 6,400 inmates we have in custody, there's about 100 in punitive segregation. And the 100 that's in punitive segregation is responsible for this. This is what they're in for. They're not in because their cell wasn't clean. They're not in because they called the CO a bitch. They're in because of violent crime. The reason I did this here, and guess what you're looking at, in case you didn't read it. These are correction officers, inmates, and civilians. And they're all what? Victim of a crime. And all I can hear the city council speak and the rest of the city council members talking about is the people who perpetrated this crime against those people in jail. And that's sad. The reality is, out of 6,400, 100 inmates in punitive segregation should say a lot to you, those of you in this room. We have answers and we have solutions as correction officers as to what we think can and should be done in order to help this situation. The reality is, punitive segregation is a jail within a jail. If you go outside this building right now and someone assaults you and the police come and they arrest them, they're going to do what? Put them in jail. Isn't that punitive? Aren't you removing them from their family? Aren't you removing them from the neighborhood and the community? Yes, that's what you're doing. So when this same crime happens inside of jail, guess what we do? We have what's called punitive segregation. Besides the inmate being rearrested and other things, this is one of the things that we do. And contrary to what people are saying up here, when they're in punitive segregation, there is therapeutic treatment for them. When they're in punitive segregation, they are being seen by the Health and Hospital Corporation. They are being seen by the Correctional Health Services. They are being seen. So, you know, this show that the city council and the city council speaker want to come up here and try to act as if correction officers are creating some type of culture of violence is shameful. And he should be ashamed of himself. And anybody that knows me know that I have family who are on this job and I have family who are locked up in this job. And quite frankly, I don't want nothing to happen to either one of them. I don't want either one of them to be injured. I don't want either one of them to be attacked. I don't want my mother to get a call because my sister, who's a correction officer, has been attacked. I also don't want her to get a call that my brother, who's an inmate, has been attacked. So correction officers are not the responsible for this culture of violence. We're basically stuck with the people that you give us. You gave us the 12 people who murdered Junior Guzman in the Bronx. You gave them to us. They were violent when they came to us. In closing, I would just like to say to the board, please vote no. Vote no as far as these changes is concerned, as far as punitive segregation. I don't think it should be changed. I think it actually should stay just the way it is. But again, like some of the people are saying, we do need to do more as far as programs, as far as trying to figure out what it is. I have one inmate, and then I'll stop. He's been in our custody. Since he's been in our custody, he's been rearrested 29 times. He's been in the punitive segregation unit 15 times. Do you think punitive segregation is working for him? Because we don't think so. But the reality is, what is it that we can do? Because the board is not addressing what we should do with these inmates or detainees who are responsible of committing crimes while they're incarcerated. The board is only voting on what should not be done to them, but they're not paying any attention to the victims of their crimes. And that needs to change, and we need to change that. Thank you very much.
Thank you. Good evening.
Good evening. I'm Mary Lynn Rolwas of the Legal Aid Society's Prisoners' Rights Project. And they were violent when they came to us. That says a lot to me of that this is what we are hearing. That it's they were violent who came to us. This is what we are dealing with. The view that a person who is incarcerated in our city jails comes in wanting to hurt other people there with absolutely no recognition of what the conditions they're being held in and how we treat them causes them to react. The question of whether violence is in fact at times reactive to the conditions in which people are placed. So as astonished as I am to hear that view so vividly put, we this evening wanted to also call out the hypocrisy of the administration that in some rooms professes to be ending solitary, that promises reforms, that talks about culture change, and yet in other rooms and in this room is asking you to codify, in essence, its worst practices. And I know that the department has stood up and said, we want reform, and you adopted the rhetoric around these rules, which is, if it were backed up by the reality, would be important. But what we're also hearing with some vitriol and rhetoric from some corners, but with the bureaucratic language of exceptions, the talismanic muttering of, well, security, is we're hearing the department as well want to work in here the same views that the union president just articulated, which is that you can have these rules, but there is a certain core of people. There are certain exceptions that we have to have. Of course, you need operational flexibility. Complex agencies need them. We all work within them. That, however, is not the same as simply saying there's a security out. We need the discretion to continue the kind of incompetence and violence that has caused so many problems in our jails. We're going to be, in our written comments to the rules, pointing out some of the ones in which the draft that was promulgated in far too many areas and in far too many ways has the exceptions that swallow the rule. The board has worked very hard on drafting rules to be comprehensive and rules that will be effective, but there are many ways in which, in the seeking to put in flexibility, they undermine their purposes. And I believe there are two other areas in which we think the same dynamic is at work, where the rules are not achieving their intended purposes, and I would just flag them here. One is with respect to our youngest incarcerated people. This board, which has some of the best-known child advocates in this city, has overseen the betrayal of the young adult plan and the dismantling of protections for our youngest people. There are protections for them in the proposed rules. They need to be strengthened. This is where we start now. And the last is this board cannot put its stamp of approval on a view that New York City cannot do any better than shackling Black men in order to control their behavior. That's what your restraint desk grace period is. And it's refusing to acknowledge there are far better ways and far more imaginative ways than the administration has professed here to address these problems with our city. Thank you.
Thank you. The next three speakers will be Martha Grieco, Jack J. Davis, and Julia Curbs. Good evening.
Good evening. My name is Martha Greco. I'm an attorney with the Bronx Defenders. At the Bronx Defenders, we urge you to adopt the Jails Action Coalition blueprint for ending solitary confinement and to give our clients access to true procedural due process. I have represented incarcerated people as a criminal defense attorney for 10 years, so my testimony is going to focus on due process. We recently formed a small unit at the Bronx Defenders to take referrals and track stories of disciplinary restrictions. Our project has been operating for several months now, and what we have seen over and over and over again is that our clients are not getting hearings. The law requires that they have a hearing before placement in solitary, before ESH, before giving them mitts to wear out of the cell, but they do not get these hearings. Instead, this is what they tell us. I'm in solitary confinement. I'm locked down all day. I'm 19 years old. DOC won't believe me because my birth certificate is blurry. No hearing. I was infracted and lost good time because I stripped myself naked after having a hot flash due to a new psychotropic medication I was taking. No hearing. I showed up to my hearing with all my witnesses, but the officer said if I insisted on having the hearing, he would sentence me to 30 days in solitary, but if I refused the hearing, he would give me 5 to 10 days. So I refused the hearing. And of course, the vast majority of our clients in solitary report that they weren't even offered a hearing. DOC lied and said that they refused it. DOC is wholesale ignoring the law, denying our clients due process, and this is happening on your watch. Board, do something about it. What can you do? Let people's attorneys onto the island. The earlier version of the proposed rule allowed this, and the provision was wiped out in the new rule. Dr. Cohen mentioned at the last hearing that this was due to cost. I want to be clear. We're not asking you to create a right to appointed counsel. We're not asking for the city to give people lawyers at these hearings. They already have lawyers. Every single person in the jails already has a lawyer. Why can't their advocates represent them in this collateral process? At my office, and at probably every public defender office in the city, lawyers already follow their clients to ancillary hearings, hearings at the DMV, hearings at Oath, hearings at TLC. We don't get paid extra for this. It's the very definition of our holistic model at the Bronx Defenders that we fight for our clients in every arena. We have advocates at our office who are not lawyers, who represent our clients in hearings at the Human Resources Administration, at NYCHA, and at meetings with ACS. It strengthens our relationship with our clients and ultimately helps us solve their problems holistically. On this issue, New York is completely backwards. Counsel is permitted at disciplinary hearings in Massachusetts, Colorado, Washington State, and a pilot program is being developed in LA. The public defender in Washington, D.C. represents clients in disciplinary hearings. They have a whole unit of their office devoted to it, and they meet regularly with the commissioner of DOC in a friendly exchange of information. It's not so novel. I commend the board for requiring videotaping of all hearing refusals, as this will do a lot to protect our clients, and for requiring DOC to notify the person's attorney that they received a ticket. But this won't stop the practice of coercing clients to give up their rights, and it won't help clients who don't deserve to be infracted in the first place. If you allow the person in custody's advocate to come to the jail to do what they do, advocate, the jails would be safer and more humane place for everyone. Denying incarcerated people due process is unacceptable, outrageous, and counterproductive. You're allowing this agency you regulate to impose torture of 23-hour isolation, and our clients rarely understand why. They're shackled to a desk, and they don't understand why. They're wearing mitts 14 hours a day, and they don't understand why. They can't explain their side of things to anyone. No wonder there's violence. No wonder there's anger. People feel completely ignored there, and that's because they are. Shine a light. Let us in. Thank you.
Thank you.
Good evening. My name is Julia Curbs, and I'm a corrections specialist at New York County Defender Services, a public defender office in Manhattan. I am here to comment on proposed changes to restrictive housing regulations. NYCDS opposes solitary confinement in all forms. Isolated confinement constitutes torture and wholly undermines rehabilitation. The practice should be abolished, but at a minimum, this board should institute due process protections for people facing transfers to restrictive housing. For the past 6 months, the Corrections Specialist Unit at NYCDS has monitored, collected data, and conducted wellness checks with every one of our clients in solitary confinement. On a given day, we have anywhere between 1 and 9 clients in solitary confinement. In total, 39 of our clients have spent a collective 774 days in solitary since July 9th of this year. When we visit our clients in restrictive housing units and ask about conditions within punitive segregation, the majority report that they never received a hearing. We demand that people in jail be given the right to an advocate at mandatory disciplinary hearings that determine whether they are placed in solitary confinement. This advocate could be the client's attorney, social worker, or other office staff familiar with the individual and his or her case. Solitary confinement is an extremely serious punishment, so incarcerated people must be given a chance to meaningfully defend themselves. Many are not familiar with the system or are unable to fully articulate themselves due to mental health issues, language barriers, or a host of other reasons. Just as we do not expect individuals to represent themselves unassisted in a courtroom, we should not obligate people to advocate for themselves without assistance in this vital context. A requirement that an advocate be notified of an upcoming disciplinary hearing would also guarantee that such hearings actually occur, something that does not appear to be happening consistently despite the DOC mandate. Collection of data is also crucial to ensuring that existing rules are being followed. Only with the assistance of advocates can we be certain that hearings are held, witnesses called, evidence collected, and appeals considered. We would know how often incarcerated people win or lose hearings, what types of charges are filed against them, and the nature of the proof normally provided to support charges. In sum, we could play our role in strengthening due process rights for our most vulnerable populations citywide. We insist on the primacy of due process, transparency, and accountability in these disciplinary proceedings, proceedings that threaten such immediate and significant harm to our incarcerated population. Permitting the inclusion of an advocate at these proceedings is one crucial step toward that goal, and one that respects the basic human rights of all people. The change is long overdue. Thank you for your consideration.
Thank you.
Hello, my name is Jack Davis.
Good evening.
And I'm a victim. But before I go any further, I would like to ask the board, right? How many people have died in the Department of Corrections since y'all have been members of the board? This is my first question. And my second question to the board is, why are we here? And my third question to the board is this: why is it so hard to make a wrong into a right when you just letting a wrong stay wrong over a right? You just told us that a person died in prison. 2 persons died on your watch. Now, when I was last here, we talked about Leland. Y'all was standing up here talking on the board that this was supposed to happen and this was going to happen and this was going, and nothing has happened. Y'all keep telling us about all these felonious rules and everything that go. Those that's been in prison know what's going to happen. The rule is going to be ignored. The guy's going to go to prison, or the girl's going to go to prison, or the LGBT is going to go to the box. What I'm asking yours that when we going to get it right? Don't stand up there and look at me like you're surprised, because that's not the answer. The answer is this. You just said 2 more people died. But we waiting for another to die? Or we waiting for 3 more to die? So you can come back here and tell us, well, you know, we feel sorry for this person that died this day for this. What I want to know from the board is this: why? Don't stand up there and look at me and be surprised, because we have a problem. And our number 1 problem is you. You, and you. You're our number 1 problem, because you want to know why? Because every time we come here, We come here to advocate about a problem. And what y'all do is escalate the problem. Because you know what? You do nothing about the problem. You just told us again, 2 more just died. What y'all want again? What do y'all want? Tell us. What do we have to do to convince you to forget it? Let solitary go. Shut it down. What do we have to do? We got to come in here in thousands and thousands of packs, right? So y'all can see that, yeah, we're strong. No, we ain't got to do that. We want y'all to use your integrity, your morals, and think about human life. And just don't say to yourself, oh, well, I listened to corrections, and corrections told me, and I listened to the officers. We understand all that. But we also want you to understand the same people you talked about that died. Look at their families. We also want you to talk about the guy that comes home that's mental health from being in the box and upsets his own family, upsets his community, upsets his neighborhood, because his neighborhood and his community don't know what to do with him or her. Because you know why? Because you let it go on. You stood up here at the same time as you was a correctional member or board and told us, well, we're looking at it. We're making slight changes, but come on. What do you want from us? I just asked y'all 3 questions. Nobody said nothing. All y'all did was look. Nobody said nothing. I asked y'all 3 questions. How many people died in the last 20 years? 374 in the last 20 years, right? Why are we here? Look at all the advocates that's here fighting to shut something down. Y'all ain't said nothing. And I asked y'all again, why so hard to make a wrong into a right? And you know what y'all doing? Y'all just standing there looking at me. You don't want me to tell you how I feel, because then y'all say I'm being disrespectful. But I'm asking y'all again, what we got to do? What do the advocates got to do to get y'all to really understand what solitary confinement, the hole, or the box is really about? What we got to do, ladies and gentlemen? Don't just look at me.
So, you know, I'll interject here, and I'll tell you that I sit here and I listen intensely and intently. And when you asked the questions, I was listening and respecting you and listening to you ask those questions. I saw them in part as rhetorical, that you were making a point. I didn't think that I needed to respond point by point by point. I'm listening to you. I'm listening to everybody that has been here at the first hearing and at the second hearing. And we will take into consideration all of the points that are being made. Judge us after you've heard the rules that come out. Don't judge us in the moment. And honestly, you don't know what it's like to sit here. You can't judge me because you don't know me. No. Let me just, no. You asked me to respond. You wanted a response. Did you not want a response? Did you not want a response? Did you not want a, okay, good deal. You wanted a response, but then you don't like the response when it's given to you. You did not want a response. I'm sorry? I don't know. Look, we're here trying to listen.
And we'll continue.
Trying to understand so that we can then respond in the best way possible. I understand that. We understand that. That's why we're here. We don't get paid to do this work. We do this because, let me finish, please. We are here because we care. You may not like every decision, but we do care. And we're here, just as you, volunteering our time and our attention because we care. You don't know what our day jobs are. You don't know what our lives are like. But you come and you chastise when we're trying to do the best that we can. So we're here this evening because we care. Thank you.
And the only way,
Thank
the only
you.
way that we're going to get to where we all want to go is we got to respect each other.
Yes.
We might not agree with every decision. We might not agree with every point of view, but the starting point has to be we have to respect each other. That has to be the basic that we afford each other. We need to stop demonizing because nobody in.
What was disrespectful? Tell me what was disrespectful. Good deal.
Yeah,
Thanks for
I think
letting-
we can't demonize each other.
No, but that's
Like,
what
we
they
have to
get
work
every day.
together. We're not always going to agree, but if we want to figure out a way forward, we have to start by respecting each other. Yeah. No, I know that. And thank goodness for y'all sticking in there and continuing to talk, because change doesn't happen overnight, right? And
What, I'm gonna, excuse me. I am gonna, we are all here. I think you have the attention of this board, and we're gonna move through the remaining speakers, okay? I'm gonna call the next 3 speakers: Mick Kincaid, Nikki Turigny, and Ms. V.
Good evening. My name is Mick Kincaid, and I'm testifying today as a member of the Jails Action Coalition. And I'm going to be reading 2 statements from people who are currently inside the city jails. And I do want to say that I think as people who have city-held positions, whether that's something like being an attorney for people, or whether that's being a city council member, or whether it's sitting on the Board of Corrections, we have to be able to hear when people who've been through extreme trauma are telling us that they want us to do better. I hear that from my clients all the time, and I often disagree with them, or I often wish they had said it in a different way to me, but that doesn't mean that's part of my job to sit there and to listen to it and then think about it. I can always be doing better, and I think all of us can, and when we hold a position of such responsibility, it's very important to hear it, and I think it's very important to remember when people have been through extraordinary trauma and they're still coming forward to tell their stories. So my first statement is from Miss Baker, who is a transgender woman inside Rose M. Singer. And she says, "My memories are the unfairness of even how the hearing was presented. There were lies written on the report, and I asked for witnesses from other incarcerated people, but they were too scared to say anything because they felt that they were going to be retaliated against by the staff. So at that point, they did not want to get involved anymore. When there is a ticket of a real seriousness, they should have a lawyer to help represent them. Even within the holding box in the SHU, even before the hearings, you should have cameras that watch the unit, because there's a mistreatment in the past where they turn on all the cold air in order to keep us quiet." So that's from Ms. Baker. And then the other statement is from Ms. Brooks, who is also a transgender woman currently at Rose M. Singer. And I wanted to say that both of these were voluntarily given to me by them, and they both said that they didn't see any of the postings. So I'm sure the postings did go up, but neither of them saw them in the clinic or the law library. So Ms. Brooks says, "On November 27th, 2019, I was housed in Rose M. Singer Center Building number 6. According to staff, this is the house where is a reception unit for the transgender male to female inmates. Upon entering this housing unit, I noticed how unkept it was, how filthy it was. I was the only person in building number 6. Not only are most of the cells down, meaning uninhabitable to live in, but the running water was brown and incredibly cold. I complained about the infestation of rodents who were running around in and out of my cell at all times, and even got into my bed a few times. While I was in there, I made several complaints, and they continued to house me in building number 6 all by myself from 11:27 until 12:01. It was Officer Lodge, who was assigned to work the 7 a.m. to 3 p.m. shift, who took it upon herself to take me to the main intake because she felt the conditions in there were not livable. She also did not want to be there herself. If it wasn't for this officer, I would have had to have another shower and brush my teeth in that dirty, filthy water that was incredibly cold. I'm so grateful for Officer Lodge, who took me out of there. I'm ever so grateful to now be housed with other women, as I should have been from the start. Thank you in advance for your assistance. And I wanted to point out, because we've been talking about restrictive housing, and we often default to talking about disciplinary, but protective custody and other kinds of isolation also should be part of this discussion, because when people are default isolated, that also causes incredible harm. Thank you.
Thank you.
Good evening, board members, and thank you for making space for this tonight. My name is Nikki Tarigny, and I'm actually here representing a group of students from Hunter College School of Social Work who are advocating for the blueprint to end solitary confinement. Just to be clear, we chose social work as a profession because we believe that people and communities can lift each other up. We promote social justice with and on behalf of the people who are most vulnerable, and we focus our attention on the environmental forces that create, contribute to, and address individual and systemic problems. In layman's terms, when we see someone who is struggling to thrive, we don't ask what they did to deserve it. We wonder what happened that led to their struggle. We chose CUNY because we want to believe that public institutions can work. We want to believe that our city can create and maintain effective systems that educate, heal, and govern our communities. But our experience in this room has brought that faith into question. As interns, we're here to advocate for justice while learning about the process of policymaking. And aside from incredible mentorship, our one privilege as interns is that for 2 full years, we get to be rookies. We get to look at everything with an inquisitive eye and ask seemingly naive questions about circumstances that we might normalize over time. Questions like, 1, why is it that board members are excused from attending monthly meetings and public hearings? The community of lawyers, social workers, and advocates that regularly fill this room are here to represent your constituents, people who can't be here because they're stuck behind bars. We recognize that you also have full-time jobs, but we're here. Is it not the responsibility of each member of this board to engage in dialogue with the people whom they represent? And 2, why is it that people talk about alternatives to isolation as though they are not an acceptable response to violence? Mr. Hussamuddin, if he were here, I would ask, when we advocate for rehabilitation instead of punitive segregation, we're not suggesting that people avoid responsibility for their actions. Anyone who's been through good mental health therapy knows that the process of recognizing trauma, undoing harm, and developing healthy coping skills is hard work. They also know that taking accountability is core to this work, and it cannot be done alone. As social workers, we promote the responsiveness of institutions to individual needs and social problems. This is a part of our code of ethics. And so to this point, mission integrity is really important to us, as we hope it is for those of you who represent organizations that employ our profession. For example, Mr. Richards, as Vice President of Fortune Society, you might, quote, imagine a world where all who are incarcerated or formerly incarcerated will thrive as positive, contributing members of society. How does solitary confinement fit into this world you've imagined? How does trauma of isolation prepare people to navigate family, community, and the workplace when they return home? And Ms. Jones-Austin, as CEO of FPWA, you've promised to, quote, advocate for groundbreaking policy change that improves the lives of millions of New Yorkers. Can you explain to us what's so groundbreaking about a solitary sentence 4 times greater than the UN's definition of torture? I don't know if Dr. Sathier is still on the board because I never see him here, but if he were here, I would remind him that he earned the nickname Dr. Social Justice by leading a medical system that cares for people regardless of who they are and trains the next generation of healthcare professionals. Yet the proposed rule allows someone to be locked to a restraint desk, unable to move freely during their few hours out of cell. What does this teach young professionals about a person's basic human right to healthcare? And finally, Ms. Sherman and Mr. Franco, you spent your entire careers promoting the welfare of young people and their families. Thank you for that. But in what other circumstance would you permit a young person to live without access to educational programming or to be locked in a room for 14 hours a day? We recognize that this process isn't easy. It's incredibly complicated, and it's really hard for us to believe that this board right here could write the current proposed rules on restrictive housing. The board is supposed to be an independent body, not loyal to the department or to City Hall. It's supposed to be loyal to the people of New York City. Any of us are at risk of incarceration, some more than others. And given the current rules that you propose, we're also at risk of being restrained, locked down, or confined to a cell. As social workers, we will not be monitors for human suffering now or in the years to come. We support the blueprint to end solitary confinement and the more than 60 organizations that have signed on to it. That's 60 organizations that this next generation of social workers will look to support after we graduate. We urge you to recognize this opportunity for a groundbreaking policy change that will improve the lives of New Yorkers, and we urge you to enact rules consistent with the blueprint to promote alternatives to violence and to truly end solitary confinement in New York. Thank you.
Now, are we ready to call for questions? Thank you for your testimony. I want to ask you, just so that I'm certain, were those rhetorical questions, or do you want a response? No, I'm just curious. Just answer. Okay. Well, I'll just tell you that when we put forth the rules into the CAPA process, what was stated here in this room, and I expressly stated it, that it was a beginning and a starting point, and that we want to hear from all of you so that we can make sure that we promulgate the best rules possible. So with respect to, your question about me and groundbreaking, that is the work that I do, and I have done it in other spaces, and I'm looking at it here as well. Thank you.
Thank you.
Members of the Board of Correction, good evening. I'm Minister Dr. Victoria A. Phillips, Ms. V, founder of Visionary V and longstanding member of the Jails Action Coalition, and have sat on the Adolescent and Young Adult Advisory Board for the last 5 to 6 years. Tonight, I want you all to remember that everything that settles ends up on the bottom. For the past 9 years, I have testified relentlessly regarding one injustice, barbaric action, or inhumane display of authority after another to this board and city council. I thank you for honoring our request to have individuals who often are unable to attend BOC monthly hearings the opportunity to go on the record this evening. Since 2014, this great city has heard the mayor's office and DOC speak of criminal justice reform, new initiatives, policies, revamping of investigations, and many other culture-shifting tactics. In fact, that was the same year City Council voted to end solitary for 16 to 21-year-olds in New York City facilities. Yet in 2015, this oversight board voted to allow DOC to open ESH, meaning this board decided to settle. As a Black spiritual woman in America, I understand all too well how settling can give one the illusion of doing what is best for all. Since opening ESH, this oversight board has chosen to settle for mediocre, untimely responses from DOC, late reporting, if things are even reported at all, corruption, and a consistent lack of accountability for officers' illegal actions. In 2018, over 60% of all sexual assault reports were reported against officers. This was reported via the Bronx DA herself at your April 2019 hearing. In addition to the 8th Nunez report released this past October, clearly stating in its 302 pages how in 2019, DOC remains undertrained, unsupervised, and unprofessional across all levels of management. When leadership settles, systems fall apart. When this oversight board settles, the ones in DOC custody suffer the most. Just ask the families of Khalif, Laylene, and even now, Nicholas. I demand that you all enact rules that are consistent with the Jails Action Coalition and Hold Solitary's blueprint released October 2019 on how to end solitary confinement in this city. Number 3 of our blueprint states end punitive segregation and make ESH and any other alternative unit actually about safety, rehabilitation, and prevention of violence. That starts with upholding those who are in control of those in custody accountable. Solitary units are torture. Having worked behind the walls, correctional walls, doing CBT, I believe solitary confinement is a mental holocaust, and anyone placed in this unit is forever changed and mentally scarred. Solitary should not be a part of DOC culture. Even the Federal Monitor reports on page 26 from the 8th report that since 2016, there has been a 92 increase in the uses of force. It also states on the same page how DOC does not have effective strategies for managing young people in custody. Page 4 also mentions DOC's failure to properly and timely document uses of force incidents. Pages 9 through 10 gives you the okay to truly set boundaries when it states how the department needs a foundation in place that can sustain and focus on compliance. Then it goes on to state the department has tried several initiatives to train staff, which has not been effective. Page 11 speaks volumes on DOC's lack of investigation and disciplinary backlog, all things that I have testified previously on. Several years ago, I sat in City Council requesting that DOC be given funding to expand its poorly ran investigation unit. Yet with additional funds, we have yet to see any real change or timely accountability. Yet this board has voted again and again to extend ESH. All the while, officers are being reported by the Federal Monitor for falsifying records, abusing their authority, and mishandling incarcerated individuals from top brass on down the line. DOC is a paramilitary agency, and as an Army brat, I know all too well how insubordination is unacceptable and not tolerated. Yet outside of the military, law enforcement agencies such as DOC are allowed to inhumanely house individuals on domestic soil based on alleged behavior, all while never being held accountable in real time for their own. We tell our incarcerated youth and young adults to do better while beating them to a pulp. We tell them to respect their elders, all the while we ignore their own cries for help. Did you hear the cries in the pages of the Federal Monitor's report? Did you hear the cries of those with invisible disabilities after Laylene died? Have you heard the cries of those with mental health concerns, such as Nicholas, who was viewed exactly as I have reported to you all previously, as less than human? I am concerned with the path that this new DOC administration is headed on. They lack the very structure and leadership needed to create long-lasting change. I was told recently that I at times get up here and I speak as if I'm threatening the board when I speak of organizing around your lack of accountability. But I point out that the one who made such a statement is still an active member of DOC and is not here tonight. Well, I believe DOC needs to be defunded and dismantled. And while I refuse to settle until lives are no longer on the line, I refuse to settle until every individual that requests sick call or is in need of medical care receives it. I refuse to settle until every death shackle in DOC is removed and outlawed. In 2019, City Council made yet another historic vote, a vote to close Rikers Island. Now the ball is in your court. Will you continue to condone torture, ill will, and enable abusers to misuse and abuse their authority under the disguise of safety for staff and facilities? Or will you say no more, not on my watch, solitary ends today? Do your job.
Thank you, Ms. Fee. The next three speakers are Ryan Brown, Eli Dreyfus, and Evie Litwack.
Hi, my name is Ryan Brown. I'm coordinator for the Brooklyn chapter of Amnesty International, also known as Amnesty International Brooklyn Local Group 27. If you don't know, Amnesty International is the largest human rights organization in the world with millions of dues-paying members around the globe. Two of the major human rights violations that Amnesty fights in this country are the death penalty and torture by solitary confinement. Well, we have the death penalty in New York State. It's called death by incarceration. 1,000 people have died in our prisons and jails while Governor Cuomo has been in office. And we have death by incarceration, and we will continue to have it unless we end our broken parole system and end the egregious practice of life without parole sentences. But we also have solitary confinement. Amnesty International has said about solitary confinement, the callous and dehumanizing practice of holding people in prolonged solitary confinement amounts to cruel, inhuman, degrading treatment and is in violation of international law. So I think we like to consider New York an international city, but how can we do so if we are in violation of international law. We shouldn't consider ourselves international just because we indulge a lot of wealthy international investment. We should be international because we uphold basic principles of treating our fellow human beings with respect and humaneness, no matter who they are or where they come from. One of the cases that Amnesty International has worked on is the case of Albert Woodfox. He was held in solitary confinement for over 40 years in Louisiana. And he has said of solitary confinement, and these are his words, the sole purpose of solitary confinement is to destroy human spirit. So what I would ask you today is what possible justification can you give the people in this room? What possible justification can you give the people of New York City not to end a sadistic form of torture whose sole purpose is to destroy human spirit? And you may answer that question if you'd like. And it was mentioned earlier today that we have to respect one another to find a way forward, but we have the way forward. We've been giving you the way forward for months now. You've got the blueprint to end solitary confinement. What more is there to talk about? You have the solution. Please just use it and just end this. Just end it.
Thank you. I'd like to remind folks who are testifying and have written remarks that they're reading that you should submit those written remarks so that we can make them a part of the record. Thank you.
Good evening. My name is Eli Dreyfus, and I work for Robert F. Kennedy Human Rights. Robert F. Kennedy Human Rights is an international human rights organization dedicated to realizing Robert Kennedy's vision of a more just and peaceful world. In the United States, we advocate for an end to mass incarceration, including the elimination of unjust pretrial detention practices that disproportionately impact the poor and communities of color. We appear before you today in solidarity with community activists, faith leaders, and elected officials to urge the complete abolition of solitary confinement in New York City jails. The DOC's practice of solitary confinement routinely amounts to cruel, inhuman, or degrading treatment, and even torture, in violation of international human rights law and the tenets of basic human dignity. The Board of Corrections bears the responsibility of ensuring that no person in DOC custody is subjected to torture. According to the United Nations Special Rapporteur on Torture, quote, solitary confinement, when used for the purpose of punishment, cannot be justified for any reason, precisely because it imposes severe mental pain and suffering beyond any reasonable retribution for criminal behavior, unquote. In line with this principle, the blueprint proposed by our allies eliminates all forms of punitive segregation in New York City jails. It requires that any other form of segregation, such as ESH, is only used as a last resort for as short a time as possible and with effective judicial oversight. Additionally, the UN Standard Minimum Rules for the Treatment of Prisoners, also known as the Mandela Rules, explicitly prohibit indefinite and prolonged solitary confinement, defining prolonged solitary confinement as anything longer than 15 days. The board's proposed rule allows for solitary confinement for up to 60 days. This is out of step with international law and in violation of basic human rights. 75% of people detained in New York City jails are awaiting trial. This should be of particular concern for this body because solitary confinement in the pretrial context is associated with additional danger and harm. According to the UN Special Rapporteur, quote, the practice of solitary confinement during pretrial detention creates a de facto situation of psychological pressure, unquote. This can influence individuals to plead guilty to an offense that they did not commit simply to end the suffering of solitary. Therefore, we urge the adoption of the Blueprint for Ending Solitary Confinement in New York City Jails, drafted by the NYC Jails Action Coalition and the Halt Solitary campaign. Punitive segregation must be eliminated. All other forms of segregation must be reimagined to provide actual therapeutic, restorative programming. DOC's use of lock-ins and lockdowns must be curtailed to allow necessary programming to continue. This could result in decreased trauma, increased continuity of care, and the opportunity for relationship building within our jails and with loved ones on the outside. We at Robert F. Kennedy Human Rights believe this is a once-in-a-generation opportunity for New York City to again take the lead on meaningful criminal justice reform. Please seize that opportunity. Adopt the blueprint. Thank you for your time.
Thank you. Good evening.
Good evening. 1 second. Short people have to adjust. Okay. My name is Evie Litwak. I'm the Executive Director of Witness to Mass Incarceration and a formerly incarcerated Jewish lesbian. I was placed in solitary for writing an article about poor medical care. In the facility I was in, all 1,300 women were seen by one physician's assistant, and whether you had cancer, a cyst, a broken foot, or a headache, his diagnosis was the same. You're fat, walk on the track, and drink water. So when Miriam Hernandez walked in looking like she was going to die, he gave her the fat speech, and 2 weeks later, she died when her gallbladder burst. He could have performed a blood test. He could have done anything to test her situation, but he didn't. And I wrote an article about this. An hour after it was posted, I was arrested, shackled, and told I would stay in solitary for as long as they wanted to keep me, which could have been years, because I wrote about an officer. Solitary is a prison within a prison, and no matter what laws you think you're writing or what rules you think you're writing, it's run by a few people, and they do whatever they want to do. And that's true across this country. I was kept in solitary for 7 weeks, a month past my release date. I have never recovered physically, mentally, or emotionally from that experience. I was strip searched, given a t-shirt, shorts, underwear, a jumpsuit, and a thin blanket. The temperature was kept freezing. I had to wear all my clothes all the time, including the blanket. And when I asked the guard for a second blanket, I was 64 years old at the time I was in solitary. They knew I suffered from anemia. The answer was no. No blanket. To understand the gravity of the situation, I want each of you to imagine you being in your own bathroom at home. Lock the door. All you have is the toilet, and where your bath or shower is a metal bed, and there is no books, no computers, nothing for you to do, no telephone, no television, nothing. You have 3 choices in your bathroom. You can stand up, you can sit on the toilet, or you can lie on your metal bed and get crippled. The question I have for each of you is, do you really think you could sit in your own bathroom for 24 hours? And I think the answer, as I cross this country and ask that question, I get maybe 3 people who are wise guys who say, I want to try it. And I say, sure, then I want to talk to you afterwards. I suffered from high blood pressure, vertigo, and migraines the day after I was put in solitary due to the fluorescent lights that are kept on all the time. It was 2 weeks before they took my blood pressure, in spite of the fact that I had a history of heart disease and that on both sides of my family, my relatives have died from heart disease. So my blood pressure, 2 weeks after I begged for it to be taken, was 200 over 100. And when I asked the guard, I said, is it time? I have a problem. I could go into cardiac arrest. He laughed, and he said, we get $75,000 on a life insurance policy if you die in prison. What you can't understand and what the rules will never show you is when you have people in a position of power with people who are not in a position of power, people abuse the power. It's historically correct. It's everywhere. So when I was given my first roll of toilet paper and I asked for a second one, the guard looked at me and said, wipe yourself. I'm a human being. I'm 64 years old. That's not an answer. But that's the things you don't see in your rules and the torture that you don't understand. The list of what I can tell you is long. I heard 60 women screaming 24 hours a day, get me the fuck out of here. And it wasn't done together. So all it was loud noise. Many women tried to commit suicide. I heard them die, those who were successful. And frankly, I didn't want to kill myself, but because of being in solitary, I looked up at God and I said, I've had a good life. It would be okay with me if I didn't wake up tomorrow. And the truth was, I didn't want to wake up. I could not take what was being done to me. And it's not only 16 and 17 and 18-year-olds who suffer. I'm 64 years old. I'm a senior with medical issues, and you can't even begin to understand the consequences of those medical issues. I was released 5 years ago. I did not know at the time of my release that the time I spent in solitary would impact the rest of my life. A very crowded subway, an airplane, an elevator caused me to stop breathing. Small spaces caused me to suffer severe panic attacks, which leads to my hospitalization, and I've suffered numerous mini strokes. My doctor fears that the next panic attack will be my last stroke. I also can't be in a loud space because it's reminiscent of the 60 women screaming. I continue to suffer from vertigo for weeks at a time, an illness I did not have before prison, which renders me unable to leave my bed. And when you come out of prison, you're poor, and you have to leave your bed in order to pay your bills. So the consequences of your economic security and the mental illness and the physical illness that you suffer from solitary combined leads you to maybe I don't want to be here anymore. Solitary confinement is a way to permanently destroy a person's mental health if you have no concern for that human being. It's inconceivable to me that in spite of the number of people testifying about the impact of solitary, the number of printed articles detailing the horrors, the body of research showing the harm it causes, that we're even sitting here discussing it. I testified before you 4 years ago in 2015 about solitary and its impact on my life. 4 years later, nothing much has happened. There's a lot of conversations. I hold you in this oversight committee responsible for the damage done to every person placed in solitary confinement. What's it going to take for you to abolish solitary? How many more deaths, suicides, mental breakdowns will have to occur before it was eliminated? If it were up to me, I'd put you in solitary, because only one of two things can happen if you were in solitary, which is you would have to see how well your rules were working. And I wrote these notes while speaking, so bear with me. You would have to see how your rules are working, and I guarantee you would understand the despair we feel. And I highly recommend that you put yourselves in solitary for a week. Honestly, because I don't think you get it. I don't want your prayers and thoughts, just like whenever there's a mass shooting, I don't want to hear the prayers and thoughts for the people that died in solitary. I want you to do something. I've been here. You made a comment that we are at the beginning of the process. This process is decades late in responding. You cannot be at the beginning of the process. 4 years ago, you were at the beginning of the process. It's too late for you to be at the beginning, because history is not going to view your actions and responses kindly as more and more people like me who've been in solitary come out and talk and testify about what you allowed to happen. Thank you for your time.
Thank you. The next three speakers are Jennifer Parrish, Cynthia Tucker, and Anna Arkin Gallagher.
Good evening. My name is Jennifer Parrish. I'm the Director of Criminal Justice Advocacy at the Urban Justice Center Mental Health Project and a member of both the Jails Action Coalition and the Halt Solitary campaign. Thank you for this opportunity to testify and for having this additional hearing. Fundamentally, the rules regarding restrictive housing must ensure humane treatment for everyone incarcerated in the city jails. The board sets the minimum standards for how people in custody must be treated, and that minimum should respect the human dignity and inherent value of each person, regardless of the charges against them or the crime for which they've been convicted. Overwhelmingly, the testimony at these hearings has shown that isolation is not humane treatment. You have heard from people who, though now released from jail, still bear the scars of solitary confinement. For the board to continue to sanction treatment that includes such pain and has such long-lasting effects is unconscionable. Instead, the board should end the use of solitary confinement in the city jails, make ESH and other alternative units about safety, rehabilitation, and the prevention of violence without restrictions on out-of-cell time. Adopt specific mechanisms and time limits for moving people out of ESH and other alternative units, create minimum standards for emergency individual lock-ins and lockdowns, and dramatically limit the use of restraints with a strong presumption against their use. The blueprint for ending solitary confinement in New York City jails spells out this vision, and our proposed rules submitted to the board in October specify how the standards should be changed to achieve that vision. We are asking the board to require the department to change its approach from a punitive one that relies on isolation, restriction, and restraints to an approach that separates individuals from the general jail population and affords them services and programming in a supportive, non-punitive environment. I'm going to focus on our recommendation for replacing solitary confinement. For the alternative units, we take ESH as a starting place because the current rules describe what it should be: housing to protect the safety and security of persons in custody while promoting rehabilitation, good behavior, and the psychological and physical well-being of persons in custody. That to separate people from general population when they pose the greatest threat to safety, but promote rehabilitation by incentivizing good behavior and providing the programs necessary and therapeutic resources. But ESH has never realized those objectives because although they espouse these purposes, the board's current standards allow for lockout time to be cut in half from 14 hours down to 7 hours, and a schedule that shifts that lockout time from 7 hours in the morning one day to 7 hours out in the evening the next, so that there are 24 hours people will lock down every other day. They also allow for out-of-cell time to be spent shackled to a desk or in a recreation cage when outdoors. This infusion of restrictions prevented those units from accomplishing the stated purpose. Instead, our proposed standards add the elements that we believe would make these units truly rehabilitative. This includes congregate human interaction, congregate recreation, and 7 hours of quality programming, including programming that's effective and successful at reducing violence. We ask for steady staff to promote consistency and predictability and community in the unit, and staff that are trained annually in the skills needed to operate the unit as a rehabilitative setting. We recommend that 50% be civilian staff or officers with social work degrees. And on each unit, each person should have an individual rehabilitation plan that provides clear guidance on what they will be offered and what they need to achieve to advance through the unit, with the presumption that they will advance and be released after 4 months at a maximum. We also call for a fair process on being placed in that unit, including the right to representation at the hearing, a neutral decision maker, and the right to an appeal. Personally, I'm stunned that the board proposed rules that will permit indiscriminate use of shackling for more than 2 years, and even still permit individualized use of restraint desk indefinitely without any process or protections. Finally, we join the Children's Rights and Children's Defense Fund and others who have called for the board not to eliminate the requirement that young adults be afforded developmentally appropriate treatment separate from adults. The city generally recognizes that services for young adults must be tailored to their needs. The board should not roll back its requirements for this population. Thank you.
Thank you. Good evening.
My name is Cynthia Tucker, and I am a mother. I am a mother of my son being incarcerated. I'm a sister, I'm a niece, or whoever you want to call. Well, I want to let y'all know, your nephew is in jail. He's been incarcerated, he's been shackled, he's been in the box. They didn't want to feed him. They put him in the box. He got in a fight. They put him in the box. And why they put him in the box? Because he wouldn't testify against who had to fight with him, because he would have been in problems. He would have had trouble being signified out that if he did tell, he'd be in trouble. So he considered staying in the box. It's unfair that we have to go through this. All of y'all up there wear glasses just like I do. I hope that you can go to a jail and sit down and see how it's being really treated, because we are unjustly unfair. You can make a difference. I don't know how to come to you. I've come to you before when the director, she left. But I'm seeing the same faces. And being mass incarcerated is not good. It's not good at all. They crying out. My son called me the other night. He said, Ma, I need help. Because I understand I need to talk to somebody. You can't talk to no one incarcerated. The officers are not going to talk to you. They're not going to let you see a counselor. He had to go do medical. They had not let him see medical yet because the fight caused him to be deaf. And they told him he LC 30, but he's really LC 20, meaning he's definitely deaf in the ear and he's not getting help. But being put in the shoe without anybody coming or hearing you, could you imagine that? Mr. Regan, can you imagine that? Not at all. So he's your nephew. You need to vote on it. I don't know what that officer was talking about. No, we say yes. We need you to say yes. Hope is here for us to fight with you, not against you, but we need you. We need y'all to come together. We need you to hear. I am a mother. I am somebody's sister. I have opened my phone up to people that are in jail I don't even know because they need us. They really need us. Well, we need y'all. I need you. My son needs you. Your nephew, I gave him to y'all just now. He needs you, along with everybody else who's standing here testifying and coming to you and pleading. But if you feel that I'm begging, then I'm begging. But if I feel that I'm asking and I'm reaching, because in our United States, who do we stand with? Are we standing with each other or we're standing against us? It's just like I have a cat. My cat was in the closet. When a cat come out the closet, it came out crazy. Well, that's what the shoot does. It makes you crazy, and it's unfair. The ASPCA take care of their animals. We, as people, that's what they do. They do create an animal. And we are not that type of people. How can we collectively come together? Because I'm coming to you pleading a case. And I know you have a heart, because your heart beat like my heart. We are of the same color. I don't care what color we are, because if you cut me, my skin gonna be white. But if you cut me, we all gonna bleed blood. The same. We all are the same. We are God's creatures. Could we come together? Could we come to a solution? Could you stop the hope? Because it's not good for nobody. My heart went out to her when she's telling me, 64 years old and you in the shoot? You can't be. Come on, she's somebody's mother, somebody's sister. She my mama right about now. And she got me by 4 years and I just turned 60. Come on, please. We need you to hear us. We've been here. This is my second time before y'all. They've been here. And I don't see the change. I see y'all looking, but I need to feel it. Because y'all know what? God forgave and Jesus saved. All right? Thank you. Thank you so much.
Thank you.
Thank you for the opportunity to speak this evening. My name is Anna Arkin-Gallagher, and I'm a senior staff attorney in the education practice at Brooklyn Defender Services. In this role, I work with our clients to help them achieve their educational goals. For young people who are in DOC custody, that means helping them to navigate a system that often seems expressly designed to limit their access to educational services. I echo many of the concerns of those who have testified already. Others, and most of all those who have experienced solitary confinement, have spoken bravely and eloquently about the trauma of solitary and have raised compelling arguments as to why these rules provide an insufficient safeguard against the harms to which this practice gives rise and the inhumanity of the practice of holding people in solitary confinement, full stop. As an education attorney, I'm here to express a set of specific concerns related to the educational rights of young people who are placed into so-called restrictive housing units, which are barely referenced in the proposed rules. In New York City, young people have the right to receive an education through the school year in which they turn 21. Despite this unequivocal right, we hear all too often from our clients on Rikers Island, both inside and outside the restrictive housing units, that they encounter great difficulty in accessing educational services. But the problem is especially serious in the restrictive housing units. The July 2018 monitoring report from the Hansberry litigation specifically called out the restrictive housing units as being perhaps the least compliant in terms of making sure young people could go to school, failing to ensure that those students in custody received the minimum requirement, minimal as it is, of at least 3 hours of school daily. The findings of the monitoring report echo what we continue to hear from the people we serve on a regular basis. A young adult recently represented by our office was eager to work towards getting his high school equivalency credential while on Rikers Island. While in a general population unit, he wasn't being brought to school on a regular basis, but after some advocacy, he told us he'd started being brought to school regularly and happily reported he was making progress towards earning that high school equivalency credential. Unfortunately, shortly thereafter, he was transferred to a secure unit. While there, his school attendance was spotty at best. Many days, no one came to bring him to school, and he received no school work. As a result of his time in secure, he lost much of the momentum he'd built up going to school. Another young person we worked with, also working to earn his high school equivalency, spent a significant amount of time in TRU. He reported he received no educational services while there. Once he came out of restrictive housing, he told us he was giving up trying to go to school on Rikers at all. It just wasn't worth it because it was nearly impossible to ever get to school. The proposed rules state that one of their core principles is the idea of promoting rehabilitation, which includes, quote, providing necessary programming. But the rules make essentially no mention of educational services and provide virtually nothing in the way of a firm guarantee. While I appreciate that the board has included some requirements to report on the provision of educational services and programming more generally, I would urge the board to make sure the rules include a clear recognition of the right of all young adults to receive educational services alongside concrete provisions aimed at ensuring young people have every opportunity to realize that right. Thank you.
Thank you. Brandon Holmes, Brooke Menschel, and Allison Dowdle.
Good evening.
Good evening.
My name is Brandon Holmes. I'm here as a member of the Jails Action Coalition in support of this board using the blueprint as defined by HALT, Solitary, CAKE, and Jails Action Coalition to end solitary in New York City. I've testified in the last hearing, but I wanted to read testimony from one of our partners and transgender woman currently at RMSC named Jenna that was provided on December 6th, 2019. My experience with protective custody was like any other men's facility because they do put us in a men's facility. When we ask for protective custody, This makes no sense. So if I have an issue with someone, I must be subject to being treated as a man due to asking for help and risk isolation. Protective custody in a men's facility is just like in general population. There's always a fight in the units and a lot of discrimination. You still deal with lockdowns, special searches, and sexual harassment. Why don't they have real protective custody for us here? Why don't we have any cell blocks to live in? My last experience in the box or solitary confinement was horrible. They served one hot meal, and that was lunch. Breakfast was cold cereal, and dinner was bologna on bread. This was at OBCC. We were locked in for 23 hours a day with 1 hour of recreation. Phone usage was limited to 1 time per month, and most times that they ran recreation, it was so early that you never got to go. They never let me out due to me being a woman.
Thank you.
Excuse me. Hi. Was that given to you anonymously?
No, Jenna.
Can you send that to me?
Yep.
Thank you.
Good evening. My name is Brooke Menschel. I'm the Civil Rights Counsel at Brooklyn Defender Services. Thank you to the board for hearing our thoughts this evening. Over the past few weeks, you've heard numerous responses to the proposed rules and suggestions on how to minimize the use of restrictive housing, especially when it's punitive in nature, and to ensure robust due process protections for people detained in city custody. All of the suggestions and recommendations have been incredibly important. Many of the comments come from lawyers like me who work on issues related to our jails. Others come from social workers and community advocates who provide invaluable services to the people detained in city custody. Most importantly, though, directly impacted people have shared their voices persuasively and compellingly on the board's proposed rules. The common thread of these comments is that they all seek to ensure that the voice of directly impacted people informs the board's process as you consider how and when to impose solitary confinement in our jails. Yet far too often, the voices of those very people are absent during the disciplinary process when the department considers whether to sentence a person to days, weeks, or months locked alone in a cell. At the December 2nd hearing, we heard that the board previously considered a provision that would allow people to bring an advocate to their disciplinary hearings. BDS and many other organizations have called on the board to adopt that type of a provision, and we were disappointed that it was not included in the initial proposed rules. We hope that moving forward, that will be rectified. Allowing for an advocate in the process would be an important step to providing due process protections guaranteed by the Constitution. Outside the jail setting, this concept is hardly novel. In employment disputes, civil actions, and all types of administrative hearings, parties are regularly represented by advocates, legal or otherwise. And as we know, corrections officers receive this type of representation when they face disciplinary charges. Certainly, incarcerated people deserve the same opportunity for their advocates to represent them. This type of representation helps amplify the voice of people whose rights are implicated. As a society, we recognize that such representation is appropriate when our livelihood or financial health will be affected. Surely we should allow for such representation when the stakes go far beyond bank accounts or employment, but are likely to result in long-term physical, mental, and emotional harm. We urge the board to require the department to develop a system that allows people to bring a representative or advocate to disciplinary hearings. Such a system will improve transparency and enhance accountability in the disciplinary process. Most importantly, it will ensure that impacted people are able to mount a defense before being sanctioned to time in isolation. You heard tonight that the legal service providers that are here are ready to work with the board and the department to develop such a system and to ensure that the people we represent are able to tell their truths throughout the disciplinary process. We hope you'll heed that invitation. Thank you.
Thank you. Good evening.
Good evening. Hello. My name is Allison Dowdle, and I am a social work intern in the Jail Services Unit at Brooklyn Defender Services. My specific role is to advocate for the rights and welfare of those incarcerated in our city jails. In addition to working as an intern with BDS, I am also a licensed emergency medical technician, where I work to ensure the safety of people who are in a state of emergency. My role is to keep my patients safe, treat any immediate life threats, and provide adequate care to people in a state of extreme vulnerability. Although I don't provide treatment to people in our city jails, I regularly hear stories of people in need of medical and/or mental health attention regularly as a part of my internship with BDS. As an EMT, I see the significant gaps within the system to request for any form of care, and sadly enough, I often learn that there are serious barriers to receiving necessary treatment for people incarcerated in all jails. A major issue that our office encounters is that the department has the ultimate veto when it comes to a person in need of medical or mental health care. Correctional officers serve in many respects as gatekeepers, without the requisite knowledge or training. The system is rife with opportunities for abuse or human error. For instance, to access medical care in a DOC facility, an individual must submit a sick call request to officers in their housing unit, who are responsible for forwarding requests to medical staff. Far too often, correctional staff can and do fail to forward sick call requests to the medical staff, or falsely claim that an individual refused to be brought to their appointment as a tool of control or punishment. While these situations threaten the health and well-being of all people in custody, they are especially dangerous for those isolated in restrictive housing units. And I want to share two examples of the harm that can result, both of which BDS has previously brought to the board's attention. Mr. R had a diagnosed seizure disorder. Following a fight, he was given a maximum time in solitary confinement, despite written notification from medical staff outlining the specific medical dangers should he be placed alone in a cell. DOC ignored concerns and kept him isolated and alone in a cell for 23 hours a day. Unsurprisingly, his isolation only exacerbated his medical condition, resulting in more regular seizures and him seriously injuring himself during a fall. Nonetheless, and despite repeated advocacy, DOC denied his transfer to an open dorm. Instead, the department opted to keep him inside a solitary cell and assigned a DOC officer to provide check-ins, and unfortunately, the officer was regularly absent or asleep. In Mr. A's case is equally troubling. Mr. A entered DOC custody confined to a wheelchair and in need of round-the-clock medical care and full-time assistance with basic activities. Nevertheless, Mr. A was sent to solitary confinement for an alleged rules violation, where he was isolated from medical staff. When our office learned of his isolation from his wife, we raised our concerns with the department and the board. While the board, especially former Executive Director Martha King, was able to advocate for Mr. A's release to a more medically appropriate housing assignment, his health had already decompensated by the time he was rehoused. In both of these cases, department staff who were not trained medical clinicians dictating housing conditions that have a direct impact on people's health care. This is incredibly troubling. While Mr. R and Mr. A both have advocates who were willing to intervene on their behalf and bring attention to their situation, these types of situations are often overlooked. DOC's impact on medical treatment requires serious oversight by the board, and for people housed in restrictive custody, we urge you to incorporate guidelines and accountability measures into the rules. As written, we fear that the proposed rules grant the department a license to continue the culture of DOC as gatekeeper to medical care. Instead, we must bolster CHS's authority and role in decision-making to ensure people in city custody have access to care that they need. Thank you.
Thank you. The next three speakers are Kelsey Davila, Brooke Taylor, and Fran Gatellis.
Hello, my name is Kelsey D'Avila. I'm with Brooklyn Defender Services, and I echo the comments made by those who are directly impacted and the advocates who have spoken here this evening, and I want to thank the many elected officials who are calling for an end to solitary and who have endorsed the Halt in Jails Action Coalition blueprint to ending solitary confinement in New York City jails. So I want to use this time to elaborate on the comments made by my colleague Allison, who spoke about the access and barriers to healthcare while in restrictive housing. Over the last 4 years, we have frequently told this board and City Council that DOC serves as a gatekeeper to accessing care. The proposed rules by the Board of Correction failed to address this flaw in the system and continue a practice that we know isn't working. Correctional health services must have the ultimate authority to remove a person from restrictive housing anytime there is a threat to the person's physical or mental health. To ensure this option is a practical reality and not merely illusory, CHS must be notified immediately anytime someone is transferred to any type of restrictive housing. Further, in order to recognize signs of decompensation, CHS must be allowed the mandate, resources, and access to provide constant and continuous rounding. By its nature, corrections is punitive. The department staff serve to fulfill the department's punitive mission. Department staff are not medically trained to recognize contraindications to restrictive housing placement. And the cases of the people that our office represents, including those that my colleague Allison described, demonstrate that it is not possible nor appropriate for department staff to make housing decisions when input from healthcare staff is ignored. And earlier today, CHS came up here and said that they are the sole entity to override DOC security. But as it's already been described, that's not exactly what happens in practice. BDS and other organizations are privileged that when we advocate for people in our jails, we are able to call the Board of Correction and DOC leadership directly to ensure immediate action, often in the case, as in Mr. A's case, within hours. You know, there are many people in jail who do not have BDS or legal aid or Bronx Defenders or the other organizations who are being represented here. And even for those who do, we often do not know that medical input is ignored until it is too late. CHS staff are on-the-ground advocates that people rely on, and it is up to the board to ensure that their input is heard and followed. The rules should address the gaps in care and prohibit DOC from making medical decisions that have, and will continue to directly harm individuals. And I want to take this time to also mention one former BDS client whose name we have all learned tragically in the last week. Nicholas Feliciano is a young man whose story should horrify us all. We will undoubtedly learn more as the investigations go forward, but what seems clear at this point is that Mr. Feliciano, a young man with a significant history of mental health needs and suicidal ideation, did not receive proper attention or treatment by DOC or CHS. We don't know the reasons, but we know the results. Without requiring CHS input and mandating that DOC cannot override a CHS decision, we fear that the proposed rules will only codify the practice we know leads to tragedy. BDS, as well as many of our allies here, will be submitting additional written comments in the weeks to come, and we urge you to seriously consider each and every point that has been raised and address them as you revise the rules. What is now merely words on paper will have an enormous impact on the well-being of people in city's care. For many, like Nicholas Feliciano, like Laylene Polanco, and many names we've all been talking about, your decisions are truly a life and death matter. Thank you.
Thank you.
Hi, my name is Brooke Taylor, and I'm a social worker at the Urban Justice Center Mental Health Project, and I regularly work with individuals whose mental health conditions have been negatively impacted by their time spent in solitary confinement specifically, and I assist them with applying for disability benefits. Due to their mental health conditions, they're not able to work. And I'm very supportive of the implementation of the blueprint by the Jails Action Coalition and the Halt Solitary campaign, but I'm here today to read a comment from someone who's currently incarcerated at MDC. So these are this person's words. To change solitary confinement, you need to change the culture of the jails, the officers, and the individuals who work here. You need to have a culture where people actually treat each other like people. This environment breeds hate. When I go to the box, I build a wall around myself. I read, I try to get my time through sleep. The box is bad. It does something to me. Every time it makes me worse than I am. Worse than when I went in. I'm always coming out of it with a vengeance, especially if I didn't do something. I'm not a violent guy, but I can become extremely violent if I feel like my safety and life is at risk. My parents taught me to defend myself, but not to the level of violence that I feel. When you are put in a cell, you get angry, and then you have nothing but time to think about how you're going to fight back. September 12, 2004 was the night I had my jaw broke. I was a kid in a fight with another kid. An officer pushed me to the ground, punched my face, and broke my jaw. They took me to Bellevue. I had surgery, and my jaw was wired shut. That night changed me forever. Every officer is a threat to me now. When I came back to Rikers in 2005, I came back fighting for my life. I've been in and out of solitary during incarceration. The first time I was ever in the box was 2005 at OBCC. I was 17, 24 hours a day. I was locked in. In the city, you aren't supposed to be in for long periods of time, but if they get a security override for the 7 days out, you can stay in the box for months without a break. This April at GRVC was the last time I was in the box. I got into a fight with another inmate and then a verbal altercation with a CO. I noticed he favored a certain group of inmates, Trinitarios. I picked a bone with him about that. He looked at me, touched his bat, and said, "I'm untouchable." That night, I was sent to the box. Officers pick a side. If they don't like you, they can mess with your solitary sentence. All they have to do is change the number in the computer to say 45 days instead of 30. Officers steal and starve people. When you lock someone in a cage, all the mistreatment breaks you down, even if you're good when you go in. I have PTSD and I have certain triggers. Because of my mom and aunt, if an African-American woman disrespects me, it really gets to me. I freak out. And if I get upset, I get stuck in the box. And if they are angry at me, I don't get fed, don't get a shower. They feed us like savages in the box, especially if they are angry at you. They walk around and ask you if you want food, but if they don't want to feed you, they don't wait for you to say yay or nay. And the box is disgusting. It's never cleaned properly, and the slot in the door and the cage around that slot are not clean. So you get a small amount of disgusting, dirty food, and you have to eat it because you need to survive, and that's all you have. Sometimes the lights, water, and toilets don't work, and there's no communication. Everything you hear is screaming. You have to yell, but you have 40 people screaming around you, so you can't actually get attention if you need it. Officers are supposed to make their rounds, but they don't. Once when I was in the box, the man next to me almost died. I had to yell and yell. In city jails, you get a 6-minute phone call every day when you are in PSEG. 6 minutes, so you call your lawyer quickly, and then you try to talk to your dad and sister, but you can't really, so then you get upset. How can you not get upset? This gets depressing just thinking about it. I can't help but think that this could be the rest of my life. Think about what's happening here. You have people who are super violent and negative operating this place. You have officers that live out in Brooklyn, commute all the way here, and work however many hours in a row. It's a thankless job. These people come in angry too because they're mistreated by COBA, and then they bring that anger to us. I see it when new officers start. You have some who start out strictly pro-officer. They're the ones who think, I don't care if you're right, you're wrong. And you have others who want to be good, who do mean well, but then they get jaded and angry, and they don't have the mental health screenings that they should be getting either. They say it's a necessary evil, the violence that comes from the officers keeping this thing going around and around. It's never about COs, inmates, cops. We are all human here. If you were a fly on the wall in this place, you would morph back into a human just to do something about it. Solitary does things to you. This place breeds hate. Thank you.
Thank you. Good evening.
Good evening. I'm Dr. Fran Gatellis, and okay. And I'm an active member of CAKE and the Halt Solitary campaign, and working with the people from JAC who, with us, have put together the blueprint that we are asking you to implement. One of the core principles that you state in your new regs is that people should not be dehumanized and should not be demeaned. Well, the testimony that you've just heard and all the testimony prior to that about the effects of solitary confinement show that no matter what you're doing, if you don't end solitary confinement, you are not keeping up with your concept that people should not be demeaned and dehumanized. That's exactly what you are doing to them. I want to address 3 particular items in the new regs. The first one is the one I spoke to you about the last time I was here a couple of weeks ago, and I raised the question of the fact that you have a time limit on solitary, and then you are constantly granting waivers so that the limit was 30 days, then person had to be put out for 7 days, and then could go back into solitary. You were granting waivers if the 7 days weren't needed. And in the process, of course, you were potentially granting indefinite solitary confinement. Now your new rule says 15 days, and then you must let someone out for 7 days. But now you're codifying the waiver so that the people in charge won't even have to come to you to ask for permission. They simply can waive the 7 days on their own. That's horrendous. I don't understand why you're doing it and how you would even begin to think that that is going to improve things. How you would even begin to think that they're not going to take advantage of the situation and constantly waive that requirement. My second point has to do with the fact that we hear all the time about how solitary confinement is a measure that is used for safety. And yet, your own document talks about the fact that there are over 800 people who've been sentenced to solitary who are sitting in general population waiting to their term to go to solitary. Now, if you think about that, it makes no sense whatsoever. If it's safe enough to keep them in general population during that waiting period, then they don't need to be put in solitary confinement. There's no logical reason. The other thing I wanted to address was in the introduction to what you had to say about youth services and specifically out-of-cell time for use. You quote from several other studies that have been doing more progressive action with youth in other prison systems. And you describe some of what they talk about as parts of the program. It prioritizes family engagement, self-expression, peer support, personal growth and development, education, and career readiness. The young adults for another study are out of cell and unrestrained, free to be in common space, a dedicated outdoor area, or one of many converted cells within the unit that serve as a library, study room, meeting room, and quiet space. That's fine. I believe that those things are necessities for youth. I would also argue that that's precisely what you need to be doing for all the adults in your custody. If you truly are dedicated to some kind of rehabilitation, then isolation, we know, for example, that one of the reasons solitary confinement is so deadly psychologically is because of the idleness. And you could see that in the example that's been given to people saying, sit in your bathroom with nothing to do for 24 hours and imagine what that would do to your head. Well, idleness is one of the destructive components of solitary confinement, and something that says there needs to be some kind of active programming, active education, active rehabilitation efforts. That's what you should be doing, not throwing people in a cell and torturing them. Thank you.
Thank you. The final person who has signed up to testify is Candy. Good evening.
Good evening. Hi, my name is Candy. I'm a member of the Jails Action Coalition, and I'm also a solitary survivor. I use the alias solitary survivor because the approximate 3 years that I spent in solitary confinement was absolute torture. I was denied rec, showers, food, sanitary napkins, and even though it's been 4 years that I've been out of solitary confinement, I still suffer from the nightmares. People say Khalif Browder committed suicide, but I'm here to tell you, he didn't commit suicide. He was killed by the police and by the Department of Corrections. One thing you cannot erase, I was not given food. I was denied religious services. But one thing that there's no cure for nightmares. I always have these nightmares that this is a dream that I'm speaking in front of you, and that I'm going to wake up and be in solitary. What kind of treatment is there to erase nightmares? The only treatment is death. I spend most of my time thinking of a way to commit suicide, to get away from the nightmares. So I don't sleep at all. I go days without sleeping because I'm afraid to go to sleep. How would you feel if it was your loved one stuck inside of an elevator and you had no way of contacting them because you could not get the telephone? The telephone is out of order, or you have 6 people ahead of you, or someone broke the phone. I couldn't even make phone calls. Before I was incarcerated, I was outgoing. I like going to parties. I like going to Sweet 16s. I like going to bridal showers. I like going to weddings. Now I don't like going anywhere. I hate the world. I'm afraid that if I go outside, I'm going to be abused and put in solitary again. I'm afraid to be intimate with anyone. As a result, my husband committed suicide. He thought I didn't love him. I do love him. I'm just afraid of being in love with him. And then I have a nightmare, a flashback that he's Captain Morgan on top of me, or Officer Terry. I'm here and I'm begging you to end solitary confinement. Solitary is absolute torture. There is no way of alternating it. The only way to alternate it is to destroy it, demolish it, end it. I'm here physically, but spiritually and emotionally, I'm gone. I sat in my cell, and I never told anyone because some people would think I'm crazy, but I don't care what the atheists think. I was here for a reason. And I said, God, if you're real, turn the light off. And if you're a believer, you know that light went off in my cell. And I questioned it. I said, no, maybe it's an electrical outage, or no, I even thought it was a bug in my brain, and they thought they were listening to me. Then I said, if you're light, turn the light off. If you're a real God, turn the light off again. And the light went off again. And I'm banging on the door, and I'm like, who's going to believe me? What am I banging for? And I lay back down. And 4 years later, I realized the reason why that light went off was for God to show me why he put me there. He put me there to tell you all that solitary is torture. Look at my arms. I try to kill myself every day, and it wasn't an act. If I was dead, I wouldn't be here to testify. But there was a reason why I swallowed all those pills, and I survived. I tied jumpers around my neck and hung from light fixtures, and I survived. I tied sheets around my neck, and I survived. I swallowed industrialized detergent, Nair. I'm not making this up, and I survived. And I'm here today to beg you to end solitary. It's absolute torture. Put people in a program where they could learn how to paint, learn how to fix a toilet, learn how to unclog a sink. It's people in solitary that don't even know how to read and write. Instead of having them sit in a cell destroying their lives, put them in a program where they can learn to read and write. And when they come out, they could be a better person than they were when they came in. Thank you so much for listening to me. I wish I had more time to speak.
Thank you. Thank you very much. And that concludes the testimony this evening. I want to thank everyone again who's provided comment today, on December 2nd, and in writing. We appreciate your sharing your experience, your expertise, and your views with us. It is an honor to be part of such an engaged and thoughtful community of people working towards safer, fair, smaller, and more humane jails. We take our responsibilities here very seriously and are committed to enacting rules designed to ensure that people in the department's custody are placed in restrictive housing in accordance with due process and procedural justice principles, and that people are confined in the least restrictive setting and for the least amount of time needed to address specific reasons for placement and to ensure their safety and the safety of staff and other people in custody. As I said at the beginning of the meeting, we will continue to welcome written testimony via mail, email, fax, or posting to the city's rulemaking webpage through January 3rd, 2020. The board will carefully consider all comments made at the hearings and submitted otherwise, and determine whether revisions should be made to the proposed rules. The board will submit final rules for certification by the law department in time for a final board vote at a future meeting. Under CAPA, any rules adopted by the board will take effect 30 days after the board vote. The board's next regularly scheduled public meeting is on January 14th, 2020 at 9 a.m. back in this auditorium. I hope you all have safe and happy holidays, and we'll see you early next year. Thank you.
And echo what Jackie said. We really do appreciate you. Look in the room. I look at the faces that are out there. Y'all have been coming meeting after meeting, and we really do appreciate it. But let me just articulate the 5 things that I feel the urgency as a board member that we need to tackle as a result of your testimony. And not just tonight, just your testimony overall. It's been very passionate, it's been very clear, and I really appreciate it. I do think the time is now to end punitive SEG, and we have to be bold as a city to be able to do it. We need to look at and end the restraint desk. Our system needs to be filled with, as a foundation, restorative justice. That has to be the principles of how we work. We need to have a vision and plan for how we deal with our young folks. We need to make sure that the due process that we laid out, that there is fair representation and support for people as they go through the process. And this is something that really crystallized for me when we went and met with the Jails Action Coalition, is that right now we do have a system that when we had Commissioner Pont, he said that the ESH was the new way of handling behaviors on Allen. And we need to fix it. It's not perfect. It's not where we want it to be and need it to be. We need to fix it. But it is a tool that, if done right, could make a difference and make jails safer for the officers, for the people who visit, and for people who are detained. And so I just want to close by thanking y'all. We heard you. I have, this is really crystallizing for me about this moment we're in. And I have confidence that every one of the board members up here have heard you and would take this really seriously to try to bring about the change we need in this moment. So thank you.
Thank you.
Thank you.